acted on the following matters in its agenda in the following manner. In the matter of GR number 212014-15, Cambe versus Office of the Ombudsman et al., GR number 212427-28, Revilla Jr. versus Office of the Ombudsman et al., GR number 212694-95, Revilla Jr. versus Office of the Ombudsman et al., GR number 212794-95, Cambe versus Office of the Ombudsman et al., GR numbers 213477-78, Asis versus Carpio Morales et al., GR numbers 213532-33, Lim versus Carpio Morales et al., GR numbers 213536-37, Napoles versus Carpio Morales et al., GR numbers 218744-59, Relampagos et al. Versus Sandigan Bayan et al. The court, speaking through Justice Perlas Bernabe, voting 13-1 with 1 taking no part, ruled to dismiss the petitions for lack of merit, affirm the findings of probable cause against all the petitioners, and to direct the Sandigan Bayan as the trial court to commence or continue all necessary proceedings in these cases with deliberate dispatch. All the petitioners had commonly assailed the joint resolution dated March 28, 2014, and the joint order dated June 4, 2014 of the Ombudsman, finding probable cause to indict them, among others, for plunder and or 16 counts of violation of Republic Act 3019, Section 3, Item E. The court found no grave abuse of discretion in the indictments, stating pertinently that, quote, the Ombudsman and the Sandigan Bayan, as to petitioners Relampagos et al., did not err in finding probable cause against all the petitioners. Their findings are fully supported by the records of this case, and no semblance of misapprehension taints the same. Moreover, this court cannot tag key documentary evidence as forgeries and bar testimonies as hearsay at this stage of the proceedings, otherwise it would defy established jurisprudential norms followed during preliminary investigation. Jurisprudence teaches us that, quote, in dealing with probable cause, as the very name implies, we deal with probabilities. These are not technical, they are the factual and practical considerations of everyday life on which reasonable and prudent men, not legal technicians, act. The standard of proof is accordingly correlative to what must be proved, unquote. Clearly, based on the foregoing disquisitions, the standard of probable cause was adequately hurdled by the prosecution in this case. As such, no grave abuse of discretion was committed by the Ombudsman and the Sandigan Bayan in the proceedings a quo. Close quote. Second item. In the matter of administrative matter number 16-08-04-SC regarding the motu proprio fact-finding investigation on allegation of 4 incumbent judges' involvement in illegal drugs, reference being made to the speech of President Rodrigo Roa Duterte delivered on August 7, 2016 in Davao City. The court issued an extended resolution, the dispositive portion of which reads, quote, wherefore, the court hereby declares that no evidence has been put forward to link Judges Ezequiel I. Dagala, Adriano S. Savillo, and Domingo L. Casiple Jr. to any involvement in the use, trade, or proliferation of illegal drugs, and thereby this fact-finding investigation against them is hereby terminated. You may recall that this case, the proper investigation, was convened by the court, and the court appointed retired Supreme Court Justice Roberto Abad as its lone investigator. In his report to the court en banc, retired Justice Abad dealt only with the charges against Judges Dagala, Savillo, and Casiple Jr., and mentioned that he is still awaiting a reply to a query he had made as to the allegation against Judge Reyes. Acting on the report, the court found that no prima facie case has been established against the said judges, and therefore it was constrained to terminate the investigation, considering that despite repeated pleas, the Philippine Drug Enforcement Agency, PDEA, insisted that no witness is willing to come forward and that it, the PDEA, has exhausted the documentary evidence it can submit. The court stated that, quote, we affirm our commitment not to shirk from our responsibility of imposing disciplinary action upon any erring judicial officer or personnel, yet we must also be steadfast in our undertaking to not be the instrument that destroys the reputation of any member of the bench by pronouncing guilt based merely on speculation. The court also took the extraordinary step of obtaining more documents on its own because of the grave public import of the President's comment. Notwithstanding this action, the court stated that its action was not to detract from the usual rule that the burden of proof in an administrative case rests on the administrative complaint, and that this case should still be considered a sui generis, or a case on its own. Among the documents obtained by the court on its own were those involving financial and commercial matters allegedly pertaining to the judges involved. The court also took to task the PDEA for making claims against the judges based on long-decided cases and relying on witnesses whose factual assertions were, on their face, not credible, and for failing, despite opportunities given during the Abad investigation, to present witnesses who could corroborate other material points. The court also noted that the judges had been placed in danger and that their reputations had been damaged by the premature announcement of their alleged involvement in the drug trade, which the investigation had revealed as unwarranted. In response to this, the court called upon various judges' organizations to take up issues that have surfaced in this investigation in order to further enable the rule of law as far as judges' conduct is concerned, so as to protect the lives and reputations of judges as far as their conduct is concerned, even as the court disciplines its own ranks. The relevant committees and offices of the court were likewise directed to convene to further the discussion on this matter, particularly on the independence of the judiciary and the due protection of judges. In a separate concurring opinion to this resolution, Justice Marvick Leonen stressed that the nature of the investigation is indeed sui generis and emphasized that the court treated the speech of the President as information only, and that the PNP and the PDEA was only invited to submit complaint affidavits or other information that it had. He pointed out that the remedy of the judges should have been to file a petition for habeas data, and that it could have been an opportunity for the judges to have been exonerated. He, however, stated his belief that, quote, the public announcement regarding the involvement of the judges concerned made by the President was at the very least premature. It appears that it was not fully supported by evidence that were professionally validated and which could be presented in a court of law. All it achieved was to shame the judges and others similarly situated. It also dangerously contributes to the President's public misperception that courts of law are incompetent. The truth is that in these cases, evidence is not available from the enforcers who could have presented opportunities for this court to clean its ranks. Crimes are wrongs against society. I am of the firm conviction that they cannot be deterred by another wrong. If you truly desire a society that works to rid itself from the menace of illegal drugs and corruption, which should strengthen the institutions that affect the rule of law, support should be given to those who struggle to do what is right. Close quote. The resolution and the concurring opinion will be released in due time, together with the Cambe decision. Questions? Gala Sevillano Casiple, and then the Sevillo, sorry. The Gala, Sevillo, Casiple, and Reyes. The Reyes investigation has not been terminated because, according to Justice Abad in his report to the court, he is still awaiting one detail that has not been answered, presumably by the PDEA.
Sir, is there, wala po bang substantial evidence or there is no evidence at all against the judges?
Let me quote the court address to be clear. The court hereby declares that no evidence has been put forward to link judges Tagala, Sevillo, Casiple Jr. to any involvement in the use, trade, or proliferation of illegal drugs, and thereby this fact-finding investigation against them is hereby terminated.
But if in that future, sir, there will be evidence that will surface po,
Well,
then the investigation...
This is a fact-finding investigation, so it's not admin. So, pagdating na lang dun, kung meron. But right now, we're talking about this current fact-finding investigation.
Dun sa regulatives po, ang question lang po is the Ombudsman's resolution finding of probable cause.
Except for Relampagos, because Relampagos is already questioning the act of the Sandigan Bayan in proceeding with the trial. But he also questions the basis of the Sandigan Bayan, which is the finding of probable cause to charge. So all of them having found, all of them having challenged the same resolution, all their petitions were consolidated because it involves the same question, whether or not the ombudsman acted with grave abuse of discretion in finding probable cause to charge them. That's the only question.
Aside from the super Lampagos po, si the Central Revilla question,
All of the petitioners,
including Sandigan Bayan's finding probable.
ombudsman lahat yan. It's the Sandigan Bayan did not find probable cause. It's only on the ombudsman.
Lampagos lang.
Yes. Relampagos lang may Sandigan Bayan. Okay, anything else?
Sir, may message ko ba ito for
May alin?
may message dito sa atin to verify yung message.
You want me to read the resolution again? Your question is there a message? I just read the resolution. Yun na lang yung sagot siguro dun. January 2nd week, I think. Kasi January 2 is a Monday. Is that right? Tama ba? 1, 2, 3. Yeah, I don't think it's January 3. Sorry, hindi ko makita yung kalendaryo. But I think it's the week after January 2. 10? Oh. Basta alam ko hindi January 3. Kasi January 3 yung first Tuesday eh. So malamang yung week after that. Okay? Anything else? Thank you. The sheets are behind you.